Hello, everyone. Welcome, welcome, welcome. How was everyone's St. Patty's Day? Did you party as hard as I did? Which meant watching movies on a couch. I'm trying to find music for us. Oh, the hard drive spun. There we go. There we go. Sorry, ears. There we go. Good morning, everyone. I'm Leonard French, your favorite copyright attorney. It's the day after St. Patty's Day here in the States. Is that a worldwide thing? I'm assuming that it's like a Irish thing. Who else celebrates St. Patty's Day? Tell me. Tell me in the chat. I want to know. Me, I went to see a movie with a friend in New York City, and that's why I was gone. It was like trying to avoid a minefield of state troopers last night on the way home from New York. Oh, thank you, Cerulean, for the poll.
I didn't do anything for St. Patrick's Day.
What do you think we should? What do you think the reward should be for last week's trivia question?
Well, we can give them the role on Discord, right? For a week. But what's the other?
The role? What do you mean the role? Like a role, like a winner on Discord?
Yeah, there's like a nice
trivia winner,
aqua green role that I made like the first time.
Okay, that's cool. Hello, Jonathan Doe. Thank you for subscribing with a tier 2 sub.
Ooh,
for
sweet.
4 months. Wow, Jonathan. Thank you very much. And Sir Knight 9 just subscribed with Twitch Prime.
Also, Blackthorn.
Thank you, thank you, thank you.
Blackthorn again also subscribed again. So thanks to him as well.
Excellent. Wow, you guys are great. So we have 4 correct trivia answers from last week, and we'll go over that. But I actually totally forgot to think up a reward. I'm a total jerk. So I'll come up with something during the show. Let me mark these. These are important. These are the right answer, people. And if we think up a different trivia question during the show, I will. I totally forgot about it this week. I'm a jerk. We have a couple cool stories for you today. It's a little bit lighter of a show. A little bit less prepared this morning, thank you. New York and St. Patty's Day and getting in late last night and all that. But this week, an executive from Equifax was indicted with insider trading. You may remember Equifax had some issues last year with losing some information, and maybe that would affect the value of their company. So if you knew about that, maybe you would want to sell your stock so that you could sell it at a higher price than what you could get after the information is revealed about the breach. Meanwhile, a man has written some scathing and critical remarks about a town in Iowa, and we all know that you can't speak badly about anyone in this country or else you get sued. No, quite the other way. The man was then threatened by his town, and so he sued his town. And we have the lawsuit from the ACLU. We'll talk about some guy who restored a car, and somebody doesn't like that. We'll talk about Miley Cyrus and whatever is happening with something with her copyright case. And we'll discuss a little bit of what's going on with Stormy Daniels, just because it's fun and salacious. And why shouldn't we discuss something fun and salacious on a nice, wholesome Sunday morning? So, good morning, everyone. Good morning. Who's hearing repeats? What?
A suggestion from Tack was that the winner of last week's trivia can choose what hat you wear today.
Okay. I didn't.
Yeah, you weren't prepared for that, though.
I wasn't prepared for a reward that I would be giving out to only one person. I was going to try to give out a reward to all four. It was the surprise. Thank you for ruining it, Tactical.
Oh.
There were only 4 answers to last week's trivia question, and they were all correct. So I wanted to say, you know, hey, I can handle 4. We'll give out like 4 $10 prizes or something like that. I can handle that. Or maybe even 4 $15 prizes. How about that? You guys, hopefully you guys can accept Amazon gift cards or something. We'll give you $15 gift cards. You got to wait a couple days till my YouTube money comes through. So that'll be our reward there. One-time thing, though. I'm not going to give out rewards to every trivia answerer every single time. But for the people who answered trivia last week correctly, you are Lint, Benjamin, Courtney, and Alexander. I don't know if you want your names read, so I'm not going to read your last names. Metis is one of them, and Lint is the other. I know you two. I don't know the other two by your names on there. If you got it correct, we'll send you a $15 gift card to Amazon or whatever your equivalent is in your country if you can't accept an Amazon gift card. How about that? Tack or somebody write that down so I don't forget about it. Because I don't mean to forget about it. I don't want to be that guy that's like, you know, why haven't you sent me my prize? Mr. French is a jerk.
Do we want to talk about what the correct answer was before we move on?
No, why would we give anybody the correct answer to a trivia question on an educational channel? So the question was, what is the name for a cylinder whose radius or diameter or whatever is this? Length is the same as its diameter, I think it is. Yeah, length is the same as diameter. Because then if you did radius, it would be like, you know, times 2. So if the length of the can part of the cylinder, you know what I mean?
Yes, the height of the cylinder.
It's tall. The height of the cylinder is the same as its width, basically. Right. So, like, if you're thinking of a square, like a rectangle that has its sides the same size is a square. What would be the equivalent for a cylinder? A cylinder that has the sides the same size would be either the ideal tin can or a circumscribed cylinder.
Right.
There are 2 correct answers there.
And how is that used? I'm guessing it's an auto thing, right?
Well, it's an ideal tin can in the sense that it has the maximum volume for its surface area, I think is the description, is the best way to describe that. And so if you're trying to maximize volume per surface area, for example, say a cylinder in an engine, you would probably want to make it exactly square, basically, so that you don't have to make it any, basically more volumetric than it needs to be.
Cool.
Beyond that, I'm not a chemist or physicist. Do I know why you would use a cylinder like that, other than for its either ideal measurements or its volume ratio.
Cool.
All right, guys, that's been a great show. Let's have a great Sunday. See you later. I'm kidding. How is everybody? I want to have some. We want to come up with some audience participation tools because I'd love to get more feedback from the audience than just chat. So one of the things we have here in the background that I've been playing with is this lamp. We might do something with this lamp in the background. I might do something with connecting the studio lights. I don't have that hooked up right now to just switch off, but we have various colors and scenes and things that we can do now and I even have underlights for my face to make it look better for you. So we're gonna program things to work with all this, and I was thinking up ideas of what we could do for audience participation, and something I'm thinking of doing is either programming that lamp to change colors based on either donations in chat or participation in chat or certain keywords in chat or certain commands in chat, or maybe somebody who donates gets control of it for a little while or something. I don't know. The lamp or the lights, or maybe we put a screen back there and there's something on the screen or something. So we're trying to think of some audience participation stuff because it's 2018 and I know that you all can't be here in the studio with me, but yet I like your feedback. I like being able to see you, and your reactions. So, and we also can't afford the bandwidth of 50 incoming streams of people's faces.
Right.
So, achievement for thank you for the subscription, Mr. Hunter or Ms. Hunter. Thank you for the 50 bits. Silent Dis, thank you for the 49 bits. All right, so you haven't missed anything yet. We haven't even gotten started. We're only 12 minutes into the stream and we haven't even gotten started yet. I don't even know what the first thing we're talking about is. I have the Stormy Daniels complaint up on my screen. I'm not even ready to go yet. That's a font. This is not even, this is so professional here.
Oh, yeah.
That's music. There we go. Where did Equifax go? There we go. There's Equifax. Let me just size these documents real quick. This is what I'm talking about here. Let's see. This one's 19 pages. That one's 7 pages. All right, so for our first, actually, you know what? I'm going to do this with separate recordings because that was a lot easier to edit last time.
I thought you were...
Who is the man without a hat? My hair looks good this morning, guys. What the heck?
I thought you were already doing separate recordings.
No, I did one long one last week, and that was kind of annoying to edit. Every time you want to use the long recording again, you have to start over trying to find everything. Right. And then I had a kind of a glitch where just in my workflow where I do some audio cleaning, some audio mastering, and just because of where I did that meant that all of that was done on one segment, and I had to then again strip copy that out and then expand it back to the full segment, then find my thing and then cut it back down to that new segment. It was really annoying. Don't do it that way. Separate recordings. Also, don't punch your microphone while your audience is listening. All right, so do we really want a hat? I can go get a hat.
Maybe Freddy today?
We can do Fazbear. Yeah, I'll be right back. All that work I did on my hair, too.
Oh.
Hello, poppers.
Hello, everyone. This is Radio Brandon. How you doing today? We're going to be listening to Leonard talk about various things. I don't think Leonard even knows this is a thing.
You want to say hi? You want to say hi? Come here. Come here. Come here. What a good boy. What a good boy. Everyone wants to say hi to you. Yes. Everyone wants to say hi to Nico. How are you? That's good, huh? That good, huh? Go boy. You're starting to fill out, huh? He's starting to look like an adult golden. You're a good boy. Alright, can you go lay down for me? Good boy. Good boy. Go lay down. Here. We'll give you some more treats. And this won't, I swear this will not train you to come do this every time you want treats. Go lay down. All right. Sorry for the interruption, everyone. I hope it was okay.
Yeah, well, everything's cool, man. Don't worry.
So for our first story today, you may remember that Equifax, one of the American credit reporting agencies, was breached. Well, it might have been before last year, but they only revealed it last year. And it turns out that, like, pretty much everything was obtained by these, by the perpetrators. Actually, I have to start over because I forgot to hit record. It's so embarrassing. So for our first story today, you may remember that sometime last year or before last year, Equifax they revealed that there had been a breach and they pretty much lost all of their data. They're one of the American credit reporting agencies, and that means they've got everyone's credit data, social security numbers, addresses, histories, everything. And for many millions of Americans, all that information was lost. Well, it turns out that one of the Equifax executives is being charged by the Securities and Exchange Commission and the United States of America with basically insider trading, if I understand this correctly. Here, the SEC complaint alleges that he committed securities fraud by engaging in insider trading illegally after being entrusted with material non-public information about the massive cyber intrusion and data breach suffered by Equifax. Ying exercised all his vested Equifax stock options and sold the shares prior to the public announcement of the breach. By selling when he did, he avoided losses of $117,000. So what are they talking about here? Insider trading is a breach of trust, is a breach of the rules of being a shareholder and an operator of a public corporation. In this case, he's an officer in a public corporation, public meaning they have stocks and are probably, in this case they are, traded on a major stock exchange. And by having access to inside information, because he's an officer of the corporation, there are rules in place about what you're allowed to do with that information. Because if you own the stock, which is owned by everyone, including the general public, and you have access to information about what's going to happen to the stock, in this case, our company suffered a major breach, therefore we can expect our stock to drop, our stock price to drop. If the price drops, he loses money, so in order to avoid losing money, he sells his stock options. The heck is a stock option? It's a weird incentive program, sort of, that companies do. They, instead of paying you for something, or part of paying you for something, they'll also pay you in stock options, which is a promise by the company to allow you to buy company stock at a fixed price for some time in the foreseeable future. So when you are an executive at a company, you are often given lots of stock options. This way you have a huge incentive to make the company grow, because that just means that the value of your stock options will grow. But the way the options work are that you don't have to buy the stock and then hold on to the stock and then sell it later. You actually can never buy the stock. Well, not never, but you can wait to buy the stock. Wait until the stock's price has gone up to where you would want to sell. Then you buy the stock with, at its low option price. So let's say $30 a share, and then maybe the stock's price is over $100 a share. So you would actually just basically get $70 a share from the company or whatever when you exercise that option. So by selling these stock options now, he avoided losing $117,000 of value on his stocks later. Let's see if they say anything more. They say he violated various laws. The commission seeks a judgment that enjoins him from future violations, orders him to disgorge the amount equal to the losses, pay a civil penalty, and prohibit him from serving as an officer or director of a public company. So they consider this a major breach of trust and don't want him to serve as an officer of a public company anymore. He's a resident of Georgia, Atlanta, age 42, employee of Equifax. Statement of facts. July 29, 2017, Equifax Security Department observed suspicious network traffic associated with the company's consumer dispute portal, which is a part of Equifax's website where consumers dispute items on their credit report. In response, the Security Department immediately blocked the suspicious traffic and continued to monitor the network. The next day, after observing additional suspicious activity, the Security Department took the portal offline. August 2nd, Equifax retained the cybersecurity group at Atlanta law firm to investigate the incident and provide legal and regulatory advice. That same day, Equifax, through the law firm, engaged in an independent cybersecurity forensic. That same day, Equifax, through the law firm, engaged in I just did it again, didn't I? That same day, Equifax, through the law firm, engaged an independent cybersecurity forensic consulting firm. Over the next several weeks, the cybersecurity forensic firm and Equifax's internal security analyzed forensic data to determine the nature and scope of the suspicious activity. It was determined that Equifax had been subject to cyber intrusions that resulted in a breach of its information technology systems. In accordance with its internal policies, the company classified the breach as a critical incident. The company designed the response. The company designated the response as Project Sierra. Forensic examiners determined that it was likely that sensitive data had been stolen. Trading blackout periods were instituted. Trading blackout periods are typically implemented pursuant to a company's insider trading policy to prevent trading by insiders when significant events or changes are taking place within the company. As part of its response to the breach, Equifax also deployed additional security measures to protect the company's network. Between August 12th and 15th, Project Sierra team members changed administrative credentials, password resets, etc. The password reset required the assistance of a broader group of Equifax IT employees who were not informed of the breach. Equifax also established a notification and remediation plan for the millions of consumers affected. That was Project Sparta. It was also kept separate from Project Sierra to limit the number of people who knew about the breach. The company decided to handle much of the work for Project Sparta through its own Global Consumer Solutions unit. On August 23rd, one of Ying's peers, the CIO of another Equifax business unit, was informed of the breach. He was also asked to lead the notification and remediation efforts that composed Project Sparta. Ying was not informed of Project Sierra or Project Sparta at that time, nor was he made aware of his colleague's appointment to lead the soon-to-be-implemented notification and remediation efforts. So they're saying up to this point, So they're saying up to this point, about August 23rd, Ying still doesn't know of the breach. But then at 2012, wow.
Done.
See you guys.
That's the story,
I'm
everyone.
out.
Let's go home.
Oh, I'm so glad we're live. Okay. I could do this. I'm a big boy. At 2:22 on Friday, August 25th, 2017, as part of Project Sparta, an email was sent to several Equifax IT personnel who were responsible for the systems that would handle the breach remediation efforts, as well as the CIOs of certain business units. Ying was among the CIOs included. The email stated that there was a very large breach opportunity that required a dramatic increase in the capacity of the relevant technology systems, extremely time-sensitive request, deadline of August 29th. Ying initially instructed his direct reports not to work on the project until they received additional information. At 4:33 that afternoon, Ying received a calendar appointment invitation for a conference call at 4:45, urgent, mandatory meeting, breach opportunity. Yes, you may also not be aware that major corporations no longer refer to problems as problems. They are all opportunities. I really shit you not. This is something they do. Like, you just... It's sort of like spending too much time in couples counseling. You start to get that certain way of speaking about you. I'm not saying it's necessarily bad. I'm just saying it has a back and forth to it. This happens in corporate America too, in its own way. This is one of those ways where everything becomes an opportunity. Wait, that's the wrong button. The invitation stated that Equifax's global CIO for all company operations wanted to get on board on this ASAP, and that participants should prepare the IT applications under their care to participants should prepare the IT applications under their care to handle approximately 10 million customers. Ying did not initially participate in the conference call, but an IT employee who reported to him was on the call. During the call, Ying and his direct report exchanged text messages in which the direct report informed Ying that Ying's team would have to cancel their Friday evening plans to respond to the Project Sparta requests. Ying then joined the conference call and initially resisted the requests for assistance. He also expressed concern that the deadline was unrealistic. In response, the leader of Project Sparta instructed Ying to call the global CIO with his concerns. Ying concludes, we'll let the headline speak for itself. At 5:26 p.m. that Friday, Ying called the global CIO. The call lasted 1 minute. During the call, the global CIO told Ying that Ying was expected to comply with the requests. The global CIO also told Ying that at that time, Ying did not need to know why he had to comply, but at some point, Ying would understand what was happening. At 5:27 p.m., Ying texted the direct report he had communicated with earlier on the phone with global CIO. Sounds bad. We may be the one breached. Starting to put two and two together. After that call, Ying's demeanor towards requests for assistance changed. Just 3 minutes later, at 5:30, the Project Sparta leader texted Ying to ask whether Ying had asked any questions after speaking to the global CIO. Ying responded. Just 3 minutes later, at 5:30 p.m., the Project Sparta leader texted Ying to ask whether Ying had any questions after speaking to the global CIO. He said, "No questions right now. Actually, I don't want to know. I told the team to rally." Ying's team began responding to the requests for assistance. Numerous additional communications the evening of August 25th informed Ying that this breach was unusual and indicate that Ying used the information entrusted to him as an Equifax employee to conclude that Equifax was the victim of the breach, and that the breach opportunity idea suggesting a client was the victim was merely a cover story. At 5:34 p.m., Ying called Equifax's global CIO again, and the two discussed the fact that the breach response plan, which called for offering credit bureau reports from all three bureaus to 50 million consumers, would be highly unusual and would strain the company's resources. At 5:50 p.m., Ying exchanged text messages with the same direct report. In the text, both men expressed that the breach situation was crazy. At 6:19, another IT employee who reported to Ying emailed him regarding a series of meetings that were scheduled to take place in different states. These meetings were to include executives as well as their counterparts and related to business relationships. Ying confirmed the cancellations of these meetings, and in his reply emails stated that, "I think you now know why." He stated that he thought the travel cancellations were related to all the mad scrambling. This continues. By no later than 10 a.m. on August 28, 2017, based on non-public information entrusted to him by his employer, Equifax, Ying concluded that Equifax itself was the victim of a major cybersecurity breach. Ying owed a duty of trust and confidence to Equifax and its shareholders not to trade on the basis of material, non-public information that he learned through his employment with Equifax and was aware of his duty. Ying knew or was reckless in not knowing that the information that Equifax was the was the victim of a major cybersecurity breach was material. Ying knew or was reckless in not knowing that the information that Equifax was the victim of a major cybersecurity breach was non-public. Ying received a portion of his compensation through stock option grants and restricted shares. While Ying had exercised some of his options previously, he continued to hold onto some until August 28, 2017. Within an hour of running the internet searches regarding the September 2015 cybersecurity breach of Experian, Ying accessed his company-sponsored stock plan with UBS Financial, exercised all of his vested options to buy Equifax shares, and then immediately sold those Equifax shares for total proceeds of more than $950,000. These securities transactions were made on the basis of material, non-public information and breached the duty of trust and confidence that Ying owed to Equifax and its shareholders. By selling Equifax shares before the cybersecurity breach was publicly disclosed, Ying avoided more than $117,000 in losses that he would have suffered had he not sold until the news of the breach became public. And then they go on to say when he was officially notified, when the public was notified, and then they charge him with violations of the Exchange Act, which I imagine is one of the insider trading allegations. There is an indictment over here from the U.S. attorney as well. This is a scheme to defraud. I'm not sure if it's under the same facts, so let's just take a quick look. Let's see, so they're saying Equifax changed the internal administrative credentials for many of its databases. Ying was aware of these changes and became aware of the breach. They make the same allegations. In violation of his obligations under the insider trading policy, Ying traded in Equifax securities on the basis of material non-public information. And then they're saying he exercised approximately 6,815 stock options and sold the resulting shares on the basis of that material non-public information. So yeah, this is the same charge. There is a forfeiture provision in here for forfeiting any profits or property in connection with it. And so that's really interesting. So the Equifax saga continues, basically. What do we think of that? I know yours truly has spoken in the past about suing Equifax himself. It turns out that there's actually a bot, the same lawyer slash programmer slash organization, whatever that is, in New York that wrote a bot to help combat parking tickets, has also used the same bot to help you, or me even, sue Equifax. So I think the plan will be, I'm going to use that bot to see what we come up with, whether we use it or not, see what we come up with in a lawsuit against Equifax. And I'll go through the whole small claims court process or county court process in my local system and see what happens here, whether it gets thrown out or not, whatever. It's a couple $100 to lose in a few hours of my time. But it should win, frankly, because this is a big deal. Like, people are going to have to deal with this breach for the rest of their lives. If the judge doesn't agree, then we'll find out why the judge doesn't agree and hopefully get some reasoning that we can bring back to you for that as well. So that's my idea, that we'll sue Equifax sometime shortly here, maybe within the next few months, and see what happens. But it looks like Mr. Ying may be going the way of Martha Stewart. This same thing happened? This same kind of charges happened to Martha Stewart after she allegedly sold some, I guess it was stocks on some similar circumstances. I don't remember exactly what the circumstances were. She allegedly told her broker to sell something, and she said that she didn't know the information that was alleged, but I believe she was convicted and served time. So not everybody goes to jail for insider trading, but when it's this egregious and this obvious, I'm pretty sure they usually charge people for this. So this is one of the ways that white-collar crimes, as they call them, are prosecuted. So hopefully you learned a little bit about insider trading today. What do you think of that?
It's pretty shady business. We do have a question regarding the case, if you...
Yes, please.
Iladriel asks, do you think it would have been legal to schedule the sale of stock option so they could be sold at the exact moment the hack was made public?
Yes. He probably could have even worked with a corporate lawyer or his own attorney to determine what exactly the timing was there. Because if the information is made public and he sells like 1 microsecond later, that might still be some kind of insider trading. I don't know. It's not enough time for the information to actually propagate. However, how much time do you have to leave for people to get the news and then decide to sell? A minute? An hour? A day? I mean, at some point, it's way too long. Like, a day is a little bit too long, right? So maybe an hour is a little bit too long. So how long do you have? There is a time there. So yes, you can probably get away with scheduling that. I don't even mean get away. I mean, it might be completely legal. However, yours truly is not a financial crimes attorney, and I have zero clue. I would need to look up, I would start looking up the laws in these documents is basically where I'd start with that. I don't even begin to know what you have to do with that. So but yeah, you can probably schedule the trade to happen at a more appropriate time, and that will be much less likely to trigger an insider trading allegation. We'll put it that way. I'll do my "it depends" lawyer weasel words.
So how much did the document say he had stock options for? Do you know what the value?
$950,000 was what he sold the 6,815 options for.
Do you know what he purchased them for?
950 divided by 6,815. So he sold them for approximately $140 a share. No, I don't know what his options were worth prior to that.
Okay, so I have the Equifax stock open here, and $140 a share was what was at the day before they announced it. So that can't be his profits, right? His options couldn't have been.
Well, what is it? Well, what is it now? Well, it wasn't his profits. That was his total revenue.
So
what is the stock at now with Equifax?
Currently, the stock has dropped back up to 123.46, and it's been staying steady for about no, it's still going up. But the lowest it went to was on September 15th, 7 days after the announcement, and that was $92.98.
So if he had just held on and not sold at that time, and it went back up to today's $123 per share,
also, if
he would have only lost $86,000.
Also, if he had just waited until the day of the announcement, right?
$88,000.
If he had just waited until, like, I don't know, like 10 hours after the announcement, the stock price would still have been at 123.23, which is about what it was at now, and he would have been.
So he would have lost $86,000, and he wouldn't be facing jail time if he had simply waited a little bit. And that's so what? So what? You got $800-some thousand out of the company basically as an incentive for doing your job. I'm not saying it's like super extra. Sure, it's your job. Like, that's your pay. I get it, but still, like, that's your pay. You agreed to be paid on something by something that varies. Like, there was a data breach. You don't get to do that. Well, they catch up with you when you do that.
The other thing is that he wouldn't have lost his job too.
Oh, that's true. He wouldn't be losing his job, and this is going to forbid him, assuming that all this happens, you know, there could be a plea deal or something, I don't know. But assuming all that they've asked for happens, they're asking for him to not only lose his job, but lose his ability to ever be an officer in a public corporation again. So, yeah, he basically has messed up his whole career doing this.
Yep, over whatever, you know.
Over $88,000. Yep. Holy mackerel. And depending upon where you live, $88,000 doesn't go very far. New York City, Manhattan, $88,000 is like 1 year's rent in like a mid-level place.
And he doesn't even get to keep the money that he sold the stocks for. He probably loses the options.
And he's not going to get to keep the money. Well, there's no more options, so he doesn't have any more options. So,
well, I mean, they probably will refund him the money he spent on the options, but they're probably not going to let him keep the options after that, right?
You know, they're asking for a disgorgement, I think, of the profits. I don't know that they're going to take more than that, other than the court will probably order some fines and things as punishment, and there'll be any restitution to anyone who can prove that they were harmed by this. But I'm assuming that the actual $117,000 in profits is what they're going after as far as the damages, and not the $800,000 in stock options, you know, that it would have been worth had he sold it properly. I'm assuming he gets to keep that money minus the fines and other punishment. That money's not being pursued as like compensation or restitution.
That's interesting. I wonder how they calculate that. Do you think they take the lowest that the stock dropped to because of the announcement and then use that as the number that he should get and then take the rest?
Yeah, I think prosecutors and defense attorneys are going to argue about that one in front of the judge.
Yeah.
Unless there's an agreement. But as you said, the stock dropped about $40 and then came back up to having only dropped $17.
$15.
So yeah, these are large amounts of money when we're talking about 6,000 shares, but I mean, we're not ultimately talking about millions of dollars. We're talking about like 80,000 versus 170,000, or 88,000 versus 117,000, a difference of only $20,000. So
yeah.
$30,000. So in the grand scheme of you're going to jail for insider trading, $30,000 is not an amount of money that I start to get upset about as an attorney. I would get upset about $1,300 in real life, but
yeah.
You know, but $30,000, you know, in a lawsuit or criminal action of this size, I would not be getting upset about that. Anyway, that aside, so that happened. Wow. Definitely let me know what you think of that in the comments. Well, damn it. We're not on YouTube. I mean, it's meant for YouTube, and I'm going to say that at the end and stuff, but, like, you guys can't leave comments on live streams. You can chat, but you can't, like, leave a lasting comment.
Well, actually, the live stream VOD has comments on it.
Okay.
chat on it.
Oh, it has chat, but it's not persistent. Like the chat scrolls.
Yes, but
It's not like the YouTube comment section, which is more like a Facebook feed or a Twitter feed or a Tumblr feed.
I would argue it's more like SoundCloud, right? So like on SoundCloud, you can leave comments at certain points during the song, you know.
Oh,
And I feel like the
sorry,
Twitch
never
chat
used
being,
SoundCloud that way.
I feel like the Twitch chat being persistent the way it is means that people making live comments now will be able to have their comments viewed if somebody views the VOD on Twitch at the appropriate time.
No, it's a cool idea. It's just two different ways of
Yeah,
working.
definitely.
So I can't say leave a comment below is really what I was getting. Where are we? Iowa Town. That's not it. That's not it. Oh, I can also stop recording. Somebody remind me to start again. Where did it go? Thank you. So. Oh, and is his website still up? Before I start, I want to just find his website. All right. So our next story is a bit lighthearted. It still involves free speech and lawsuits and the ACLU and all that. But the question we ask today is, should you move to Sibley, Iowa? Well, only you can answer that. This man has lived in Sibley, Iowa his whole life. He created a website, surprised many readers to learn that he really does enjoy living there. However, there is a blood plant. It is an animal processing plant that receives financial assistance from the Iowa Economic Development Authority, according to this gentleman. And it smells terrible. It basically, he says it smells like rancid animal, the whole town. So he put up this website, and it has some things about stuff going for it and some things about stuff against it. And this gentleman, you know, he was opinionated enough to put up a whole website about it. In fact, we can just leave that up there for a second. This is the gentleman, and it turns out that he has received a lawsuit threat against him from the town complained of in that website. Okay? However, threatening people with lawsuits is often enough to get certain lawyers' attention, and when you threaten people with lawsuits for things that they've done in free speech, you often get the ire of the American Civil Liberties Union. So, without further ado, I present to you the lawsuit of Joshua Harms versus the city of Sibley, Iowa. It's 23 pages long. We'll go through it at a fairly good clip here. I don't know what's in it. I'm assuming it's mostly free speech, First Amendment stuff. This civil rights suit seeks to protect the right to engage in core political speech at the heart of the First Amendment. Plaintiff Joshua Harms, a lifelong resident of Sibley, Iowa, who loves his community and wants to see it thrive, is facing a prior restraint on the content of his personal website, ShouldYouMoveToSibleyIA.com, as well as unconstitutional retaliation for his criticism of the city of Sibley, Iowa, and its municipal government. Oh, good. Thank you, Tactical. You already put it in the chat. Like many small Iowa towns, Sibley has struggled to maintain its population and most crucially to attract enough well-paying jobs to retain its younger population. To help remedy this problem in 2013, Sibley used tax breaks to lure the Iowa drying and processing plant to move its operations to Sibley. While fortunately IDP employs 26 individuals, unfortunately it comes with a pungent and foul odor that has been the subject of numerous nuisance citations and of protracted litigation between IDP and Sibley. Frustrated by IDP's odors and Sibley's inability to adequately control the problem, Harms created his website. His goals were to inform the public of the ongoing problem, to criticize the inaction of Sibley and its officials, and to spur on his municipal government to financially take action to rein in the odors. Eventually, thanks mostly to Facebook shares, the website went viral by Sibley standards with over 2,000 visits in a matter of days. That's viral. Finally drawing the attention of Sibley City Council, over 3 years after the creation of the website, Sibley City administrators and Sibley City clerks gave a presentation to City Council on Harm's website and the alleged harm. Okay, so here's an interesting typo for you. Someone obviously was making sure that every spelling of Harms was correct, and they actually meant to use the word harm with a lowercase h and no plural here. Sibley City Administrator and Sibley City Clerk gave a presentation to City Council on Harm's website and the alleged harms it was causing Sibley. Following that presentation, defendants directed its attorneys to issue a cease and desist letter to Harms to get it down by threatening litigation unless he altered or removed his website. Reasonably intimidated, he did. Brazenly, the city's attorneys then further instructed Harms not to speak with the press about their censorship of the website. One of the cornerstones of our constitutional democracy is the right to be free from prior restraint or retaliation for engaging in protected expression like the website Harms posted here. But for Harms, this constitutional right was abused by the very public servants who took an oath to uphold the Constitution. Accordingly, plaintiff seeks damages and declaratory and injunctive relief to enjoin defendants from bringing a retaliatory lawsuit and to enjoin defendants from preventing plaintiff and to enjoin defendants from prevents plaintiff what? Yeah. And to enjoin defendants from preventing plaintiff from changing his website and speaking with any reporters interested in speaking with him about his website or the city of Sibley. So, aside from that last train wreck of a sentence, it's a fairly straightforward lawsuit. The First Amendment protects your right to the freedom of speech without prior restraint by the government. It doesn't mean that other people can't say things. It doesn't mean that you have the right of free speech in someone's private business, and it doesn't mean you have the right of free speech in all cases. But it does mean that the government cannot put a prior restraint on your speech that doesn't fit into one of a handful of exceptions like safety. For instance, you can't shout fire in a crowded restaurant, something like that. Unless there actually is a fire, you can't shout it. You can't like incite panic with your free speech. So now, if your free speech is that all people are equal and that certain minority groups should not be so oppressed, and that incites offense, that's not the same thing. No, we're not talking about that. We're talking about actual like health and safety stuff are really some of the only things that the American government can do, at least, to infringe on your right to free speech. So if I want to put up a website that says my town sucks, I'm allowed to do that. Are other people in my town allowed to be upset about it? Absolutely. And maybe I want to be cautious about what I say because I'll have to face the people in my town. But the government can't make me take it down. And if they try, you should contact the ACLU because they will come and fight for you in many cases, especially where the case seems like a good case. If not, there are a decent number of First Amendment attorneys that would love to represent in cases like this as well. And a lot of those attorneys have banded together as the ACLU, and it's really it's a very sought after organization for attorneys who are concerned about civil rights to join. Many attorneys will take a pay or career cut in order to get into the ACLU. So they do some good work. Not everybody agrees with them because they don't fight for your cause all the time. They fight for the constitutional rights that are allowed. So that might mean that they fight for freedom of speech for someone you don't like. Maybe you don't like the speech that they're fighting for. It's not about the speech. It's about the constitutional right of everyone to the speech, to the free speech. That's what that's about. Any thoughts, questions, concerns? What do we think of that story?
Question from Jabberwocky69. If the case goes to trial, what is the ballpark cost for the attorney's fees, do you think?
Oh, I don't know. ACLU would probably be logging their time properly and probably charge you full price. So I'm gonna guess over $100,000. It depends on how far it goes. The city already made these threats, and that is enough to get it into court. So now it's just a matter of when the city concedes. This is a city of a few thousand people, so they're not going to be able to pay the ACLU's attorney's fees. They may want to concede the case now, pay whatever they need to pay now, and get the heck out.
Question.
So it's probably already in the 5 digits, knowing the ACLU. So, frankly, that town should do itself a favor and get out of this one. They don't have the right. And then when you add into it that they asked him to not tell anybody that they talked to him about it, that is further infringement on speech, and that sort of takes it into like a more malicious or more reckless or more knowing territory. Like they knew that it would be critical, and that's exactly the kind of speech where you need to have free speech because the government won't allow critical speech. So we're getting into territory where a judge might actually punish them by tripling the damages or something like that. So the town is seriously in hot water if they don't handle the rest of this properly. It may already be in serious hot water.
C Puma Stirred asks, couldn't the city have asked nicely without threatening legal action and not be in violation of the Constitution?
One more time?
Couldn't the city have asked nicely without threatening legal action and not been in violation of the Constitution?
Oh, yeah, and you see this every time you get pulled over in your car and the officer walks up and he says, do you mind if I search your car? You know, maybe he doesn't say it immediately, or she, but they walk up and they say, do you know how fast you were going? Do you mind if I search your car? He's not asking, please step out of the car. I have a warrant to search your car, or I have a reason to search your car. He's literally asking for permission. So if the city had contacted their attorney or whatever, and they had sat down and worded it properly, they probably could have written a pretty good letter that outlined why they would like him to take it down, and asked him politely to take it down or modify it without actually infringing on his rights. So they could have communicated their disdain without threatening him. Instead, they went to abusing their authority. That's what the problem is here. They went straight to using, basically putting a prior restraint on free speech without passing a law about it. They basically just said, we're going to sue you, instead of explaining to you how you violate the Constitution or the law in some way. That's not quite how that works. Spitfire, thank you for the subscription. Always appreciated. All right, now I know many of you have been waiting for this next story, and we even waited a little bit longer so that all of you would be here and you wouldn't miss it. Of course, I am talking about Mr. Sam Crack. Now, is that really how you pronounce it? Like, I'm gonna have to call him Sam Crack this whole time?
You just call him Sam, but I am
Okay.
pretty sure that's how it's pronounced.
I might just pronounce it Sam Crack. Anyway, so he buys this car at salvage, and it looks like this, I think. It's in pretty bad shape. Let me see. Let me put this up on YouTube here, or we can put it in theater mode. This car is in pretty bad shape. It looks pretty much totaled. What do we know, just in case you're not familiar, what do we know about being totaled? When a car, even though that car doesn't look terrible, it would probably cost more to fix that car than the insurance company says the car is worth. Now we're looking at the car that Sam has fixed. Sam took probably many hours and a lot of time and fixed the car, but restored it back to its original condition, including the Domino's logo that you see on there. And of course, Domino's is a trademark. It's for a pizza company in the States. Actually, they're international. I'm pretty sure I've seen them in every country I've gone to, which is only Europe and Mexico and Canada. But I'm pretty sure Domino's is pretty much every place. So Sam takes this time to fix this car, but he's not just fixing the car, he's also restoring its original condition, including its artwork, which happens to be a trademarked logo, colors, etc. of Domino's Pizza. And then he allegedly gets some kind of letter or something, some communication from either the PR firm or a lawyer or something telling him that he's not allowed to have this car, not allowed to use this car, etc., etc., etc. Do we have a copy of the letter? I don't know if he's actually revealed the letter.
We do not. I reached out to him for a copy of the letter, but we haven't received it yet.
What's on the GoFundMe? Let's see. Now the car is being threatened to be either taken from our ownership or be deconstructed, since whomever allowed it to be taken into the possession of the insurance company made a mistake. Okay, so that's what they're saying, that they accidentally turned it over to the insurance company. The fact that this organization offered to dismantle the car tells me they're not interested in the car itself. He was restoring it. Okay. What we don't know then is what more he intends to do with the car. I did hear him in this very video say that he intended to deliver pizzas with the car. So I thought today maybe we should go over kind of the spectrum of what you can and sort of can't do with trademark and all that. Give me one sec here, because I have a couple sources that I wanted to point to, and I put them, of course, in the wrong browser, because that really helps you guys. Or maybe I didn't. So, Sigyn, yes, if he removed the branding, that would probably be one thing. However, he is sort of a car purist, and it seems like he wants to restore the car as in for show. Now let me pause this for a second and take you to the International Trademark Association's website. This is a fairly prominent organization in trademarks, and they have a fact sheet here on fair use of trademarks. They have a list here of what are fair uses of trademarks that we could go over. For example, photographer's use of Barbie was a nominative fair use because his work was criticism of Barbie. A nominative use is a use by name, for example. That's not it. Here we go. There are two major kinds of fair use that are recognized for trademark. Nominative is one where you refer to something by name, such as a printer produced by Casio being a Casio printer. And a descriptive fair use, such as when Paul Simon describes Kodachrome film in a song. The point of trademarks is to designate the origin of a good or service, to connect a good or service with the company through its branding. This way, when you go to the store and you buy a yellow container of Tide detergent, you can be sure, or relatively sure, that what's in the bottle was actually made and produced by the Tide company, that they are responsible for its contents, that you can rely on the quality to be quality that is attached to Tide. It does not mean that Tide can't make a shitty product or whatever. It just means that you will always associate that branding with that company as the source of the good that you're purchasing or the service that you're using. With Domino's trademark on this car, the rights sort of overlap. There's a bit of a Venn diagram of Sam's uses and Domino's rights. So one key point in here was that Domino's alleges they made a mistake. According to Sam, Domino's alleges that they made a mistake in allowing the insurance company to salvage the car. That's a possibility. Oh well, they sold the car. I don't know that there's any legal right to obtain the car back when you accidentally sell it and don't immediately attempt to undo the accidental sale. It had to be months later that this car was repaired and they finally got around to letting him know they didn't like this. I don't think they missed the car in the time being. So I don't think that comes into it really at all. What really comes into it is that it's a Domino's branded car. I don't think that the special nature of it being a pizza oven car or whatever really has anything to do with it either. I think, again, all rights of sale and title were extinguished when it was transferred to Sam. What really is happening, in my humble opinion, unless somebody can give me a better read on this, because I'm certainly not above being wrong about something from time to time, but my initial reaction, and after a little bit of research, it's that Domino's branding is still on the car, and Domino's doesn't know what he's going to do with the car. Remember, we think back to that trademark stuff being a source indicator. So if it is indicating the source of goods, what's happening if Sam, who's not associated with Domino's and not delivering pizzas, is driving around in a car like that? Let's go through the whole spectrum together while just watching this video for distraction. If Sam is restoring the car and it is going to sit in his garage and do nothing, no one is ever going to see it again beyond the restoration of the car and it sitting in his garage, is that a infringement of Domino's trademarks? Probably not. There's no way that anyone can misunderstand or confuse the source of Domino's goods and the source of this branding with Domino's and with what Sam's doing. So how about if Sam goes to a car show and he takes the car to the car show and he shows the car and he says, "Look at what a great restoration job I did on this." And let's say that he takes the car to the car show by trailer. He doesn't actually drive the car on the road, just for this purity of the hypothetical. I still think he's in the clear. He might even do himself a favor by including the phrase, "I am not affiliated with Domino's Pizza. This car is not affiliated with Domino's Pizza," or something like that. He'd probably want to talk to a trademark lawyer about that. Now, what if he wants to drive this car around on the road? What if he just wants to drive this car around on the road? I'm starting to hit a gray area for me, because someone could recognize this car and say, "Oh, look at that cool Domino's car. I wonder what Domino's is up to today." Or what about that jerk who just cut me off in the Domino's car? Like, Domino's no longer has control of its branding because the car's on the road out in public driving around like normal. So they were starting to hit a gray area. But let me go a little further, and I think it'll be clear where the line might be. So what if he wants to deliver pizza in the car? He said something in one of his videos about going to a school or charity or event or something and delivering pizza using it. Well, that's a cool idea. It's got a pizza oven in it. It's like the ideal car for it. But it's still got the Domino's branding on it. How are you going to convince everyone involved, including the people taking photos of the event, including people taking photos from the event from afar? How are you going to make sure they all know that none of this is associated with Domino's? You're not. That's going to be really hard. And then finally, let's go full bore, full hyperbolic. What happens if you are literally delivering pizzas in the car for a competitor? Now you are definitely confusing the source of goods. Now I agree, a caveat or element to that last scenario is that you'd be delivering pizzas for Joe's Pizza in a Domino's car, but the people who ordered the pizza knew they ordered from Joe's, and the people who saw the car aren't like ordering pizza from Domino's because they saw the car, or ordering pizza from Joe's because they saw the car. So you've still got arguments here. This is not a pure open and shut case. There's some huge gray area here. But what you don't have, and let me just start this video again here so that we can see. What you don't have is Domino's having the right to to get the car or something like that. At the most, Domino's can probably make some sort of agreement or reach some kind of middle ground via a judge, if necessary, that he will only use the car for certain things or in certain ways, that he won't misuse its branding, and that if he does misuse its branding, they have the right to something or other. Or he might simply agree to remove the branding, which might just be as simple as maybe removing the Domino's themselves. He can probably even keep the colors and get away with it. Maybe Domino's has a trademark on those colors in that scenario as well. Either way, he cannot legally use the colors and logo and such and the car in connection with selling, distributing, making, anything to do with pizza, basically. That's the limitations of trademark. It's an indicator of the source of goods, and so the moment that he starts to confuse consumers about the source of goods is where Domino's trademark rights really kick in, and kick in pretty hard. And I would expect them to have a complaint, have some kind of claim in court, some valid claim in court, if the Venn diagram of Sam Crack's uses starts to overlap with with Domino's trademark rights in protecting the source of their branding and their goods. So there is a claim here. Domino's is not wrong for being concerned. Maybe they're a little wrong for coming at him this way. They probably should have explained all of this like I just explained to him and just said, look, we can't have you using our branding in connection with selling pizzas. So, here we'll offer you some money for the car. Thank you for your hard work. And frankly, why didn't they offer him a decent buck for the car? Like it's a beautiful job that he did here. And they don't like the legal situation they're in. It's their legal situation that they're in. Just give them a couple more dollars for the car. Jeez. People are really stingy these days with some of these things, in my humble opinion. If he's not selling if he's not selling people, if he's not selling pizza, Brigand 231, if he's not selling pizza, then it's not a copyright trademark issue. He bought the car. Trademark or copyright issues are extinguished with the first sale, so he doesn't have the right to copy the branding, but he does have the right to restore the car. A judge might have to help me further whether his act in restoring the branding to its original condition was also some kind of copyright infringement. I don't think that's how that works. We've had that in landscape cases before, or in architecture cases. You can repair architecture to its original artistic decorative form without infringing on the copyrights of the people who designed the house. So this should be the same, as long as, once again, he doesn't go the additional steps of confusing consumers about what he's doing with the car and whether he's sponsored by Domino's or not, which could be really easy to do if he does the wrong thing with it. So hopefully that makes sense.
I wanted to clarify a couple of things.
Sure.
The suggestion that he would go to a school for disabled children and deliver pizzas, that was only on the table with Domino's as an alternative to selling them the car. So he was like, I don't want to sell you the car for that price. You guys don't seem to be willing to go higher. I would like to maybe set something up, like we can make good use of this. Let's bring some pizzas to some kids and that kind of thing. That was what that was.
Okay. That's really awesome and very charitable of him, and I like this guy, the more I found out about him. But he has to make sure that he understands trademark law and what he can't get away with, what he can't do using a Domino's car. He basically, in my humble opinion, and this is not legal advice, he probably can't drive it around the road. Like, even though the car is working now, and I realize that negates a bit of his investment, he probably can't drive it around with that branding on it because it doesn't belong, the branding does not belong to him, because it would confuse consumers about, who's driving the car and what they're doing with it. Could he, if he wanted to drive the car someplace, to drive it to the show or whatever, just get some of those vinyl those peel off whatevers, and just put some vinyl cover-ups over it, some magnets or something, which I realize is not ideal. You have to make sure everything's freaking clean so you don't scratch stuff and all. I get it, but he could cover it up so that he doesn't violate anything while he's driving it on the road.
Yeah.
But if he starts driving it on the road, he could start confusing things. And definitely if he delivers pizzas with it, which, whether or not that scenario was as I said it, I meant what I said about the judgment of that scenario. If he delivers pizzas with it, that should probably be the clearest violation of their trademark. It's not that he can't have a restored car. It's that he can't have that branding. And branding is something that's active. It's not that once it's on the car, it doesn't matter anymore. No, branding is active. If you start to use it in commerce now, it'll be confusing to consumers, and that is exactly what trademark's for. So yes, a judge will think this case has some kind of merit, depending upon what the sides say. If Sam says, I've never done and never will do any of those things that Domino's is worried about, then the judge might say, then there's no case here. Domino's is just worried that you're going to do something. Maybe you want to make an agreement with Domino's, and hey, Domino's, maybe you want to stop being so stubborn, because the two of you both have rights here. We probably should work it out. Actually, when I spent some time in divorce court judges used to do this, and I think this is a great scenario for it. I've had judges take the attorneys and say, you are not leaving this courthouse until you work this out. Go into that conference room and agree to something. And I've literally had judges say that. And I don't know how much the judge's power actually extended to enforcing that statement, but I didn't want to find out. So we went into the conference room and we worked it out.
There was one other thing. One other possible plot twist with this case is that he mentioned that the email came from a Gmail address and not from some kind of official Domino's address. Now, I mean,
okay.
that's
possible.
Yeah, it's possible that somebody at Domino's is using a Gmail address, which, you know, that's fine.
Or a legal representative. Lots of attorneys still use Gmail addresses. I don't recommend it, but even I, for example, I have 3 email addresses we use in connection with the channel, and one of them is just a regular old Gmail address. The other 2 are run by Gmail. They're just private domains. Yeah. And actually that same G Suite account runs a whole bunch of domains that we use, but mostly Lawful Masses at leonardjfrench.com and my personal Gmail account are what's used. So yeah, I could see someone sending it from a Gmail account, but you're absolutely right. When you send a demand letter and it just says, hey Joe, it's Bob, please take the thing down, you know, it doesn't sound like as authoritative as, you know, Dewey, Cheatham and Howe law firm, you know, I represent so-and-so. This letter is consider this letter a formal demand letter for your to cease and desist, yada, yada. It sounds so much more powerful when you do it that way. However, in this day and age when people have the internet and we're all kind of a little bit more educated on some things at least, we all know that this doesn't have to be done this way.
Right.
And so it just comes off as stubborn and strong-arming and frustrated. Like, I can't comprehend why anyone would ever buy a unique vehicle and want to restore it and then want to show it. What an amazingly stupid thing I can't possibly comprehend. Like why would you write a letter that sort of comes off dismissive of this person's hard work, is what I'm saying.
But the point that I was trying to...
It's not the attitude to start with, sorry.
No, it's okay. The point that I was trying to possibly make is that there's been no public... statement from Domino's on this. There's been nothing from Domino's, almost nothing from Sam other than the video and the GoFundMe. It's possible that this isn't even Domino's sending him this letter.
It is possible that it's a scam. Somebody saw the video and said, let's prank somebody. It's possible. I don't.
Yeah, it's not incredibly likely though. I mean, this is a pretty big scam, you know.
So it's got 406,000 views listed here on YouTube right now. I'm assuming someone from Domino's has seen this, and if they weren't the ones behind it, they would be dealing with it.
Right.
Also, he has another video that says he bought another Domino's car.
Yeah, but that one doesn't have the branding on it.
Okay. So now, just to go to that scenario, if he buys another Domino's car and it doesn't have the branding on it, and he goes and puts the branding on it, that's a little bit different of a scenario too.
Right.
You can probably do that. Like, somebody can probably have a Lawful Masses branded car, like, in their garage for private show that doesn't get put on the internet. The moment that it goes into the public stream of commerce, Lawful Masses is our trademark, and you can't use that without our permission. And you may remember, trademarks can be diluted. If you say Kleenex too often for tissues, then Kleenex becomes generic. If you say Xerox too often for copies, then you get Xerox becomes generic. So companies have to protect their trademarks, and they also have to protect the way other companies use them. If they don't enforce their trademark rights and properly license them, they can lose them as well. Called naked licensing, trademark dilution, and genericide are those 3 topics for anyone interested.
I have a question for you. So in regards to, if their main argument is about him making videos, right? Making videos showing the car with the Domino's logo on it. Okay, he made a good point in his video where he showed that another person has a video where he eats Domino's pizza and is showing the trademark but is not associating himself with Domino's. He is only eating pizza. Are those two things equivalent in terms of enforcing trademark? And if they enforce the trademark on his video, do they also have to enforce the trademark usage in the other person's video too?
The standard, so I was only listening to about half your comment, I'm sorry, but the standard is whether it is confusingly similar to a jury, basically. So it's not as black and white of a question as some. You'll have to put your scenario into your head as like, what would like my average reasonable citizen who would pass into a jury pool, who would like actually get picked for a jury, what would they think of my scenario? Is the scenario where the Domino's car is there, but Sam is just eating pizza out of an unbranded pizza box? That's really close. Like that's still pizza associated with branding for Domino's. So you'll probably have to put a disclaimer on that. Some of this stuff will probably have to come with a big disclaimer, I'm not affiliated with Domino's Pizza or something like that, when he's doing anything that could come anywhere close to infringing. I didn't listen to your first scenario because I was getting the Miley Cyrus thing ready. Sorry.
Well, it's not just a scenario; it's an actual video. It's just he showed a video of a person eating Domino's pizza, with the Domino's box in plain view, making comments about Domino's. And then, so my question was, were those two videos
with the car in the background?
No, not with the car in the background, just with the Domino's logo on the box.
Oh, you can eat pizza like on stream and something like that. Is there a point at which so some companies do this, like you'll see this on Mythbusters, for example. They don't want you to see the brands of things that they use, lest you think that those brands are associated with Mythbusters. There is something to that, and it varies a little bit from state to state, but my general understanding is that no, you're not usually supposed to be using brands on TV like that or on shows like that. Even me having some of the things that I have in the background could potentially be a violation. I'm not full 100% clear on exactly how you work through all of that, but it's one thing if I say you need to use an 8-inch saw blade and then you happen to see that the 8-inch saw blade I use comes from a certain brand. What I think big shows are trying, like much bigger shows than mine, are trying to prevent are anyone thinking that a brand that they used is a sponsor of the show. And it's not that they would get hit with 1 million trademark violations if they showed everything. It's that they might get hit with one, and they don't want to even deal with one. So even if it turns out that they're right, even if it turns out that they made a fair use of the trademark, they just don't want to even deal with it. So rather than have to even think about it, they just use some tape or marker or whatever to black out the branding on something when it's going to be prominently displayed on screen. For example, I drink my Appalachian root beer a lot. And for the amount that I do this and show you that I'm drinking root beer, you might think that I'm actually sponsored by Appalachian Brewing Company, and I'm not, just to be clear. And to further be clear, the reason why I often show the label on the bottle is because it looks like a beer bottle, and I want everyone to know that I'm not drinking alcohol, especially on stream. For one, I'm 38 years old almost, and alcohol just doesn't affect me the same way that it affects normal people. Like, it has a stronger effect on me, and I often need like next to none of it to get like seriously intoxicated. So you probably will never see me drunk because it doesn't take much at all. Also, then the after effects are terrible. So I just don't drink that much anymore. So that's one reason why I don't. And two, I don't think it's really something I want associated with my content. So I love my root beer and I have no problem with my root beer. So sometimes I show the label to make sure that everybody sees that it's just root beer and no one thinks that I'm drinking on stream, like drinking alcohol on stream. Dead Viney says, no drunk stream. Generally, no. Maybe when I separate the Twitch live stream into a separate gaming stream, which should happen here in the next few months or so. We'll probably ramp up to a separate Twitch channel and start streaming on both, and then ramp down on this one on the gaming. so that this one is the Lost streaming channel, or whatever. One of them will be Lost streaming channel, one of them will be gaming channel. Those I might be a little bit intoxicated for. But generally these shows, especially on Sunday mornings, like I don't want to be intoxicated for them. They're already hard enough to get through some of this material. Okay. Speaking of hard and difficult material that comes in like a wrecking ball, Miley Cyrus is being sued. I actually kind of forget what she's being sued for, so let's jump into it. Plaintiff Michael May is a songwriter. Miley Cyrus is a singer and performer. All Relevant Times defendant Theron co-wrote defendants We Can't Stop the infringing musical composition. At All Relevant Times mentioned defendant Thomas co-wrote We Can't Stop. Something about the Virgin Islands, using stage names. Do you want to get into like some summary here, or is this going to be in this obtrusive legal language the whole time? Okay. It bothers me when attorneys have to use that repetitive, unhelpful language. That at all relevant times herein mentioned. Plaintiff May is a Jamaican songwriter and recording artist who has released several hit reggae singles in the 1980s and 1990s. He has recorded for various producers and collaborated with internationally known reggae artists such as Freddie McGregor, Bless My Soul, Sanchez, Madly in Love, Ninja Man, Zip It Up, and Thriller U, Girls Just Wanna Have Fun. In or about 1988, Plaintiff May solely authored, created the song We Run Things, which was musically arranged with the assistance of Cleveland Brown, Haldane Brown, and Wycliffe Johnson. We Run Things was released to the public in 1988 and became a cultural hit, garnering significant sales and popularity both domestically in the Caribbean region and internationally. Specifically, December 88, Plaintiff May's We Run Things became a #1 hit in Jamaica. The song was additionally met with great acclaim in the UK, Canada, and USA. Since its release, We Run Things remains a favorite for lovers of reggae music worldwide. Through his own creativity and originality, he created the original creative lyric phrase, We run things, things no run we. We run things, no run we. Wow. We run things, things no run we is distinctly Plaintiff May's, having its roots in Jamaican patois with its own unique phraseology and linguistic combinations that, when translated into English, is not grammatically correct. The literal English translation of We run things, things no run we, or its colloquial is We run things, things don't run we. The correct grammatical English translation is Things don't run us. We run things, things don't run us. That at all relevant times herein mentioned as solely created and authored by Plaintiff May, it describes an attitude of personal freedom and situational control. Plaintiff May's protected content was completely original, complete, and unique. In 2017, Plaintiff May sought from the United States Copyright Office formal ownership protections. Apparently he registered the copyright, it looks like. Defendants have exploited and continue to exploit and greatly profit from We Run Things in We Can't Stop. Defendants' infringement is continuing to the present date. Includes unlawfully creating, recording, manufacturing, etc. Defendants' infringement is the unlawful appropriation of plaintiff's... Defendant's infringement is the unlawful appropriation of Plaintiff May's copyrighted material, including the original creative and unique lyrical phrase, We run things, things no run we. Without seeking to obtain any form of advance permission, defendants intentionally and unlawfully used Plaintiff May's original, creative, and unique lyrical phraseology as the repeated chorus and hook in We Can't Stop. That's interesting. The entire theme of We Can't Stop would be hollow in sound and impact and would fail to achieve stated success without the unique thrust of authenticity and the substantially similar theme provided by Plaintiff May's original protected content. That's really interesting. I can't remember how both songs go at this moment in time, and I don't know that I have either prepared to play on stream legally. So I won't do that now, but I will try to prepare something about what the difference is between the two songs for the inevitable release of this VOD on YouTube. Oh, that's not it. Do this transition this way. It goes on about Hannah Montana and the use of the song, etc. That she exchanged her good girl profile for a gritty and hypersexualized image. That she sought contributions from popular U.S. and Caribbean writing and production fixtures, including the defendants. Defendants sought this valuable writing production input in order to authenticate and add credibility by association to her new aggressive sound. Cyrus is very publicly looking to the American urban music scene and Caribbean music scene for inspiration in her evolving career. That defendant Cyrus and her team have sampled various songs from a cross-section of musical artists. That in 2013, defendant Cyrus, Theron, Timothy, and Mike Will co-authored and produced We Can't Stop. That it contains the creative and original lyrical phrase, "We run things, things no run we." That the hook accounts for 50% of the substantive content of the song. And they go into some detail about how they think the song and its hook are important, and that it's the hook, this "we run things, things don't run we," are the most important parts. And then they go into something very important here. Just for a reminder, in order to have copyright infringement, you have to have actual copying or access and substantial similarity. So they've just been spending a lot of time talking about how similar they are, in that the hook was the same as the lyrics to the plaintiff's song. Now they're going to start talking about access. So this is what they mean by having that. You have to have access to the song. In other words, if you don't have access to the song and you come up with something substantially similar without having ever heard the song, that's perfectly legit. But if you come up with something similar, substantially similar to another song, and you have heard that other song before, that's copyright infringement. This is an important distinction. Defendants undoubtedly had access to We Run Things prior to writing and releasing We Can't Stop, given its wide commercial success, and given defendants knowing of, including but not limited to, defendants Theron and Timothy and their creative, their previous hit. that at all relevant times herein meant, yeah, stop reading that. Defendants Timothy and Theron of Rock City are Caribbean born and contributed significantly to the writing of We Can't Stop. They stated in a Vibe magazine article, we incorporate Caribbean culture because that's who we are and that's the base of our creativity. You have to listen. Specifically, he added, you have to listen like we run tings, tings don't run we, and hands in a de air like we don't care, as they incorporate that bottom of who we are, that root, into the music. That at all relevant times herein mentioned, defendant Timothy, the second half of the Rock City duo, similarly admits in the same Vibe interview, we pull so many different melodies from Caribbean music because we like to believe Caribbean music has some of the best melodies in music. And then they will continue to go on here in what I'm assuming is great depth for another 16 pages about whether or not they had access and whether or not these are substantially similar. And from there, I'm assuming that they will go on and ask for a disgorgement of profits and or some kind of statutory... It couldn't be statutory copyright infringement, I don't think. It would have to be actual damages. So they're going to be seeking actual damages in a case like this. So that's really interesting. And you get to learn a little bit about copyright infringement. Again, copyright infringement is either direct copying that was unauthorized, or it is coming up with something that is substantially similar, which could involve direct copying. A lot of times artists will take and make a direct copy and then work from the direct copy to make something that is substantially similar but not a direct copy. Well, they still had access, so that's still copyright infringement. Plus, if you had to testify to all that, you'd also have to testify to the part where you copied the thing and then worked from there. So these are not ways to avoid copyright infringement. The best way to avoid copyright infringement is to come up with something creative on your own. It can be inspired by something, but it cannot be substantially similar. And again, the test for substantial similarity is often whether or not a reasonable jury would agree under the circumstances that the things are substantially similar. So you can't just say, well, I wouldn't find it substantially similar. No, you have to think about, would a jury of 8 or 12 of my peers agree that it was substantially similar or not, including peers I don't like, including peers that don't agree with me on things, including peers that don't share my political or cultural ideologies or whatever. The regular voting citizens that can be jurists, those are the people you have to convince that you are not making something substantially similar. So we'll keep an eye on this one. This is really interesting, and see what happens from here. These things are often written hyperbolically, so I don't want to say, oh, I side with the plaintiff, having not heard the defense. This is just the plaintiff's side. I have not heard Miley Cyrus's response. We'll see what it's like. Yours truly has actually successfully pursued claims like these. I had a client who had their hook used in someone's song, and that someone went on to be a more prominent artist, or at least a prominent artist, and the person admitted that they used my client's song as an inspiration, not realizing that that's copyright infringement. And so we literally asked, hey, do you know that this was our lyric? And the person said, yeah, of course it's your lyric. I love you guys. And that was unfortunately also copyright infringement. So we had a conversation about it, and we decided that we would ask for a certain amount of money, and it was a small amount of money, rather than ending someone's career or really making a big stink or something. But someone should have at least licensed that for that hook for use in the new song that was then going on national media, basically. So, really interesting case, in my humble opinion. We'll be watching that. What do you think? Let me know in the chat, in the comments, on Twitter, etc.
Quick update on the Sam Crack case.
Yes.
Sometime in the past hour, the This is actually coming from Kirito 1678. Sometime in the past hour, the GoFundMe stopped accepting donations.
Okay.
That's all we have.
How much was it up to?
$5,917.
Maybe he either feels like he got enough, or maybe he finally talked to Domino's or something.
It's possible. But I just thought you might want to know that. Everybody might want to know that. So.
Okay. No, that's a good update. And I have that recorded. We'll put that in the VOD. Okay. And last but not least, if you have young children or anyone who does not want to talk about Stephanie Clifford and Donald Trump, or Peggy Peterson and David Dennison, you might want them to leave the room. I'm not going into gory detail. You just might not want to have to explain it. So, just fair warning, we're going to talk about Stormy Daniels. This is a complaint for declaratory relief that has been filed by Ms. Clifford against Mr. Trump. I don't know what's in it. I believe that it seeks an invalidating or voiding or confirmation of the voiding of the non-disclosure agreement that was signed by Ms. Daniels and allegedly not signed by Mr. Trump. If you are not familiar with this story, you've been living under a rock. No, I'm not going to go any further with that. Factual background. Ms. Clifford began an intimate relationship with Mr. Trump in the summer of 2006 in Lake Tahoe and continued her relationship well into the year 2007. This relationship included, among other things, at least one meeting in a bungalow at a Beverly Hills hotel in Los Angeles County. Mr. Trump announced his candidacy for president in 2015, secured the presidency, and then, on October 7th, 2016, said that he doesn't even wait when meeting a woman to start kissing her, and when you're a star, they let you do it, you can do anything. Within days after that tape, several women came forward to tell their stories about sexual encounters with Mr. Trump. Around this time, Ms. Clifford likewise sought to share details concerning her relationship. As a result of her efforts aimed at disclosing her story, Ms. Clifford's plans came to the attention of Mr. Trump and his campaign. Ms. Clifford's plans came to the attention of Mr. Trump and his campaign, including Mr. Michael Cohen, his attorney licensed in the state of New York. Mr. Cohen worked as the top attorney at the Trump Organization from 2007 until after the election, and presently serves as Mr. Trump's personal attorney. He is referred to as Mr. Trump's fixer. After discovering Ms. Clifford's plan, Mr. Trump, with the assistance of his attorney, Mr. Cohen, aggressively sought to silence Ms. Clifford as part of an effort to avoid her telling the truth, thus helping to ensure he won the election. Ms. Clifford and her attorney were presented with a non-disclosure agreement. At the time, Ms. Clifford was represented by counsel in California. The parties named in the hush agreement were Ms. Clifford, Mr. Trump, and essential consultants. As noted above, EC was formed on October 17th, just weeks before the presidential election. On information and belief, EC was created by Mr. Cohen with Mr. Trump's knowledge to hide the true source of funds to be used to pay Ms. Clifford, thus further insulating Mr. Trump from later discovery and scrutiny. By the design of Mr. Cohen, the hush agreement used aliases to refer to Ms. Clifford as Peggy Peterson and Mr. Trump as David Dennison. Attached are the agreement and the side letter agreement that make up that agreement. It imposed various conditions and obligations not only on Ms. Clifford but also Mr. Trump. The agreement also required the signature of all parties, including that of Mr. Trump. Moreover, as is customary, it is widely understood at all times that unless all the parties signed the documents together with all of its terms and conditions, then it was null and void. This is a critical assumption here. October 28th, 2 days before the election, 2 of the parties signed the hush agreement. Mr. Trump, however, did not sign the agreement, thus rendering it legally null and void and of no consequence. Despite the failure to sign the agreement, Mr. Cohen proceeded to cause $130,000 to be wired to the trust of Miss Clifford's attorney. He did so even though there was no legal agreement. Mr. Trump was elected president. In January 2018, certain details of the hush agreement emerged, including, among other things, the existence of the agreement, the parties to the agreement, and the $130,000 payment. On or about February 13th, 2018, Mr. Cohen issued a public statement regarding Ms. Clifford, the existence of the hush agreement, and the details of the hush agreement. He did so without any consent by Ms. Clifford, thus evidencing Mr. Cohen's apparent position that no binding agreement was in place. Mr. Cohen stated, "In a private transaction in 2016, I used my own personal funds to facilitate a payment of $130,000 to Ms. Stephanie Clifford," etc., etc. If you're not familiar with this story, seriously, you can go see it in a million other places. Because the agreement was never formed and it is null and void, no contractual obligations were imposed, including any obligations to keep information confidential. And they go a little further. Let's see, declaratory relief, and that's it. So what they're looking for then is a judge saying, yes, this is null and void, and you can continue to act like this agreement is null and void. Well, we have something educational. I would not present this to you unless this was educational. I have something educational for you here about this case, I swear. A notice of removal was filed by the Trump administration or by the defense counsel, removing the action to federal court. This is an automatic thing. As long as they meet the requirements, they automatically go from state court to federal court. And so I thought we should go over the notice of removal, and you'll see why they did this, and you'll see what removal is. Because how often do we get to go over removal in an interesting case, really? To the clerk and the court, the federal court, please take notice that pursuant to these following laws, Defendant Essential Consultants, EC, with the consent of Donald Trump, defendants, hereby removes this civil action from the Superior Court of California for the County of Los Angeles to the U.S. District Court for the Central District of California. This court has original jurisdiction. The amount in controversy exceeds $75,000, and the parties have complete diversity, which means that they are from separate states. On March 6th, an action was commenced in Superior Court by Stormy Daniels, the action that we just read. Neither of the defendants has been served. Plaintiff asserts in the complaint one cause of action. The settlement agreement between the parties contains a broad arbitration provision which provides that any and all claims or controversies which may arise between Clifford and DD shall be resolved by binding confidential arbitration to the greatest extent permitted by law. On February 22nd, pursuant to the arbitration agreement, EC commenced an arbitration proceeding regarding the controversy at issue in this lawsuit before ADR Services, the pending arbitration proceeding. In the pending arbitration proceeding, EC seeks compensatory damages, liquidated damages, and injunctive relief of $1 million per breach. Plaintiff Clifford and her counsel were aware of the pending arbitration proceeding at the time they filed the lawsuit. They refused to comply with the arbitration agreement. Therefore, EC intends to file a petition to compel arbitration. So the major crux at the heart of the facts is that Stormy Daniels says that the agreement is null and void because Donald Trump never signed it. And even if it is somehow not null and void, it's been violated by Michael Cohen, and therefore Stormy Daniels can violate back. Sort of eye for an eye breach of contract theory. I don't know how that actually works. The first theory of it being void is probably the stronger one. But then Trump's side is coming back and saying, no, that's a valid agreement and it contains an arbitration provision, so we have to go to arbitration. Let's get this put through arbitration. But the educational part of it is this part here, really. Grounds for removal. As set forth more fully below, this court has subject matter jurisdiction under original jurisdiction for all civil matters where the amount in controversy exceeds $75,000 and the parties are citizens of different states. This is otherwise known as diversity jurisdiction. So they talk about the amount in controversy being satisfied. The sum in the complaint is $130,000, and the damages at issue they're saying are $1 million per breach, or $20 million, which is just sort of a guesstimate of how many times she has allegedly breached. That complete diversity of citizenship exists. Basically, Stormy Daniels is a resident of the state of Texas, and Trump is a resident of, I think, New York, or at least Washington, D.C. at this time. So they are from different states. And then here's the normal prerequisites for removal. First of all, the statute provides each defendant shall have 30 days after receipt of the initial pleading to file the notice of removal. Since it's well within that, there's no problem there. It's properly removed to the Central District of California because that's where the underlying action was pending. A law requires a copy of all pleadings to be provided, which they have done. And a law requires that notice be provided to the parties and the court, which has been done. By filing this notice, EC does not waive its right to seek to compel arbitration. If any question arises as the proprietary of the removal of this action, EC respectfully requests the opportunity to submit briefing and oral arguments and to conduct discovery in support of its position. Wow. So they wanted to remove that to federal court, probably because they hope that they'll get maybe faster or better resolution in federal court on the arbitration issue. So we'll see. Maybe the federal court will not agree that the arbitration clause is enforceable since the agreement was never signed by a required party. Or maybe the court will find that the $130,000 was paid and kept, and that the agreement didn't need to be signed. It was effectively signed by the actions of the parties. We'll see. I really have no idea. This is another one of those contract interpretation things. I would have to research state law, which we do from time to time, and we do have a contract flow chart that helps us understand the research required to root out any ambiguity, vagueness, or misunderstanding in a contract, and it's very long. So we don't always do everything that's very long. Sometimes we skip. So thank you for joining me for that. I wanted to read what that was all about and also share what removal is about in federal court. Any questions or thoughts, comments, concerns? Well,
I don't think we have any questions regarding this, actually.
okay. It's a kind of a clear controversy. It's kind of dramatic, but other than the names involved, it's really not that big of a deal. If this wasn't Donald Trump and a porn star, it wouldn't really be that big of a deal.
Right.
So this week, we are working on some news stories for you. I know there's the Stardock case that everyone's been asking about. It's very long and very complicated and contains 30 years of or more of history. So we've been parsing this out and are going to make a very detailed video for you that should just be rapid fire of everything that's going on in the case, including claims and answers and counterclaims and all that. So that should be really interesting. I think there are some other cool stories we have this week for you, but I've totally forgotten what they are off the top of my head, at this moment in time. So I'll just skip ahead to saying thank you very much to all of my supporters. You support on Twitch now, you support on Patreon. I've had some of you send me donations directly through PayPal. That's awesome. You guys are amazing in what you'll do to keep this channel going. The adpocalypse does continue to hit us. I can tell you that the videos get remonetized faster, but the effects of getting demonetized in the first place still do hit us. So it's not like we're making $1 million on top of the Patreon donations. Right now it's working out to be about $1,000 of YouTube income a month. And so that's a good number, but that's not what it used to be. We're actually really down on the income, even though subscriber numbers and view numbers are either up or at least holding. So it's a little weird that the channel is growing, but the YouTube revenue is not on a legal education breaking news channel. It's really weird that we keep getting demonetized like this. So no, we're not going anywhere. We're going to put up with it, and the reason we can put up with it and weather the storm is because of your donations on Patreon and Twitch and really every other way that you support us, by sharing, by commenting, by participating, by just being a great viewer, is really all that we need from you to keep going here. So thank you very much to those of you who have done the have done more and have sponsored by paying your actual hard-earned dollars. My $50 plus supporters for the month of March are DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrock, John H. Anderson, Vera Montaigne, and Sean McNamara. When I post this VOD, I will have the $5 plus supporters scrolling on the screen. You're also on the LED panel behind me, which I update on the first of every month with all of the supporters who subscribed or supported during the previous month. And that's how Patreon charges you too. So if you start supporting in March, you'll actually be charged on April 1st, and you'll receive your recognition in April. Just so everyone's clear, we really haven't had any complaints or anything, just wanted people to know how that timing works. So thank you very much. I do see that we are almost up to $2,000 a month in Patreon donations, which is absolutely wonderful. That is exactly the kind of budget that I need to make this, to really put more and more time, effort, and money and people into this. There will be more people involved in this channel as that budget grows. Not because I'm greedy, but because people need to eat. People need to take time to work on stories, and that means not taking time to work on making money. So when Tactical Bra is working on stuff, the more she's working on stuff. When Brandon's here on Sunday mornings, we're not doing other stuff with our time. That's great when it's a little bit of our time, but when I'm going to start asking these people to be assistants and managers and content directors and social media coordinators, they're going to need to get paid a little bit for that. So as the channel grows and can support them, we're going to just keep growing with them. No matter what happens, we're going to keep going because I absolutely love doing this for you. You're a wonderful audience, and this has been a dream come true for me to produce this show for you. So thank you very much, everyone. I'll probably put some other sponsorship opportunities and things on the screen here someplace, and if I don't, then I'll just cut this out. So thank you, everyone, for joining me this Sunday morning. I will play us out and grab a dog or two. And I am, of course, Leonard French, your favorite copyright attorney. And I'll be right back. And I'll see you in the next video, of course, for the rest of you on the VOD. That works. That's my boy. That's my boy. all the way. Big dog. This is my big dog. He sees himself on the screen. What a face. We woke him up. That might be why he looks a little rough.
Rescorpion says, I wasn't expecting the dog to enter the room doing the Charleston. I don't think Leonard can hear me right now.
I can sort of hear it. So I'm also probably echoing a little bit back into my microphone. Such a good boy. Raw. Okay. Raw.
Do you miss me at all? Do you think about the things we used to do? No, you couldn't stand tall. So why didn't you call? So many years has gone by, but I think about you all the time. Looks like you're changing and all, but why didn't you call?
Yeah, he might have been sleeping and we just woke him up a little bit, so he's just not quite awake yet. He's a good boy.
For those asking what song that was, that's my favorite song that we play on stream, Let's Bounce by Gavin Moon.
So thank you for joining me, everybody. How did you enjoy today's show? How'd we do, Brandon?
We did a good job.
Okay, we got all that recorded. I still need to pull the VOD off of Twitch because I forgot to hit record on one or two minor things.
Okay.
Hey, Hosted Radio, thanks for hosting me. We're about to close the show.
Sad.
That's very nice. No, I appreciate it. I really appreciate it. But that's the end of the show, actually.
That's all she wrote.
Looks like you're changing and all, but why didn't you
It has been such an adventure. It's been a really, really cool adventure.
Always something in the air. Inexplicable, I can feel it.
Yeah, sorry about the daylight savings time. That I knew that would happen. I thought there might be somebody or one or two people who missed because of the hour difference. I apologize for that. I don't know how to solve this problem. I'll put in suggestions.
I tried to mitigate it by making an announcement on Discord last night, but that was all I could do. So.
Flea Stomper, the live stream was on YouTube for the patrons. If you're a Patreon patron, you'll get a notice of the 9:30 a.m. live stream on YouTube. The live stream itself is the proper live stream is always on Twitch now. YouTube has a habit of demonetizing us, which is not a terrible concern for the live stream all by itself, but the demonetizing comes with depromotion, and it seemed like our channel was starting to really take a turn for the worse when I was posting the live stream on YouTube as of about October of last year. We stopped doing the live stream on YouTube and the channel began to improve. Its statistics and things began to improve. So I really think we triggered something of YouTube's promotion system. as much as they say they want us to use their live streaming technologies and things, when I use them, the channel seems to suffer. So until YouTube can reassure me that that was a bug or something, I'm not trusting them, and I'm not going back. So let's maybe hit 100,000 subscribers before I start messing with it again. That's my thought.
For sure.
Anyway, I'm going to go get some lunch. You guys have a great Sunday, and I'll see you this week when we drop some of our videos made from this stream, which is what we use this stream for. And I will also have other produced videos this week, not the least of which will be the Stardock video, which I know everyone is looking forward to. Also, I don't know if DJ Gilcrease is listening, but we're just about finished with the script on the Lexmark stuff, or at least the pseudo script on the Lexmark stuff. So that should be within the next week or so. Definitely by the end of March on that, DJ. Thank you very much for your support and patience. Anyway, love ya. See you later. Bye.